Sounds like something that you have me.
Oh, yeah, I do that with some people. I do that with some people. It's almost like.
All right.
Oh, yeah. I'm like, hey, I told Scott, I need him more. Right, because he's like the controller. He's like, man, don't mess with my schedule. Yes. Right. I love it. I love that. I don't worry about where we're going. Some of it's, you know, so they said they. Hey, there we are. Yeah.
Yes, because it's in engines. Except those three.
Place.
It's probably on this phone on this.
Yeah.
It's always gonna be crap. because-
Look at that.
Yeah,
It's like it's happening.
still.
Mhm. I don't know, I noticed fumbling more and more. I used to be such a tech guy. I can't handle it.
It used to be my main thing.
Oh, yeah, me too. Are you still as strong at it?
Different way. I still program and code that are excellent.
Okay,
Just, that's my fun.
so you still, yeah, still.
And I understand this. But
Tony, I wanted to let you know that I am now on.
that's the IDR, cybersecurity. I just do that on the side.
Selfless puzzles, yeah.
Now I have people, so to make, you know, because you know, I'm an unusual president since I actually, so I can never just say, well, you can do that. No, we're already doing this. Supplement. Are we good? All right. We'll call the meeting to order. Appreciate everyone's patience. Good news is, other than the training, the rest of the agenda should flow through pretty quickly, which is good. So we will call to order. And can we do roll call for the record? Say your name, please.
Al Born.
Very good.
Matt McCracken.
John Gamelke.
Tony Perry.
David Mijares?
Rebecca Riddell.
Arden Weatherford.
And
Rusty Neal.
Jerry, lead us in the pledge.
Allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Right, okay. We do have minutes in the packet for September 6th, 2022. I will say that there were just some small edits with spellings like Bergstrom Park and those kind of things. And they're in your packet now, but they're probably different than the ones that Miss Allen sent to you. So I'll entertain a motion to approve the minutes of September 6th.
Bourne moves to approve the September
6th.
minutes
Yeah.
as amended. Is that appropriate?
Well,
Or
it's in
as
the packet,
presented.
so it's as presented.
As presented, okay.
I'll second it.
Second by Mr. Neal. Good morning, Rusty.
Good morning.
Very quiet.
Are there any comments, additions, deletions? Okay, we'll call for the question. And again, we'll do it by roll call, just to make it easier for, Mr. Levy's going to take notes for us since Miss Allen is gone.
Bourne, yes.
Good, yes.
McCracken, yes.
Gamelke, yes.
Perry, yes.
Mijares, yes.
Riddell, yes.
Weatherford, yes.
Neal, yes.
All right. Okay, in your packet is just one invoice because I don't believe we received the invoice from our attorney for September yet. So this is an invoice for Mrs. Allen's time. So there are no TIF reimbursements and there's no changes to the financial report. So that's not in there this month. So I'll entertain a motion to approve the invoice for Miss Allen.
I'll make a motion to approve. Matt McCracken.
I'll second. Mijares?
Thank you. Roll call, or any questions, comments? Roll call, please.
Born, yes.
Good, yes.
McCracken, yes.
Gamelki, yes.
Perry, yes.
Mijares, yes.
Riddell, yes.
Weatherford, yes.
Neil, yes.
So I'm going to cover 5B and C real quick, just to let the board know what's going on. We have the Tava Group here today with their attorney. We have our attorney present. So after this meeting, we're going to meet and just have a get to know you session and discuss not only the sale agreement, but also the development agreement. Remember what we had asked Tava Group to do was to have their attorney draft the initial agreement so that our attorney and we could review it and use it as a starting point for coming to an agreement. So we will not obviously make any decisions at those meetings. It's just discussion. It's just a back and forth. As always, anything that we think we're in agreement with will come before the entire board and be done in public. So, but it is the first get to know you, sit across the desk, walk through the challenges from the DDA perspective. We've made it clear that we're going to stay consistent with what we've done in the past. We're open to TIF agreements, but those will probably be done by individual parties going into Woodland Station. We have to do what's in the best interest of the city in terms of any deal that we do. We have the general sales number that we agreed to, but there's still some details to work out with respect to the assets on the property, such as the cog rail, the picnic tables, the piece of art wagon, those kind of things. So anyway, so we will not obviously come to any formal agreements during this meeting. It's a work session, and since Mr. Neal is not present, typically I've kind of pegged him to be the person with me when we work with the attorney, primarily because he's on the city council, and we thought that would be a good conduit to make sure that the council and the city are aware of what's going on. But today, Mr. Gamelki, as vice chair, will join me in that meeting. So, okay. So with that, I would like to reintroduce Mr. McCaskin. He is our DDA attorney, and he drove up this morning, and he's going to give us a training on conflict of interest. And we do have a microphone set up. Hopefully that'll work.
Looks like it's on. So can everybody hear me? A-okay?
You're
Chairperson,
broadcasting.
Perry, thank you for that introduction. It's nice to be back up here this morning. Karen, your planning director, has graciously agreed to help drive my PowerPoint presentation. So maybe I'll give it just a minute here and get that pulled up. If you could just click on start presentation, we should be ready to rock and roll. Okay. Oh, maybe say enable editing.
You are broadcasting the presentation.
Okay, but it should be able to show just the presentation. Well, when they're getting that set up, let me, as Chairperson Perry just mentioned, I'm going to talk to you this morning about conflicts of interest and ethics in Colorado. Elected and appointed officials in Colorado are subject to a variety of legal and ethical obligations when carrying out your duties. As a general matter, DDA board members are fiduciaries to the public at large, right? So any decision that you're making really should be a decision that is in the best interest of the entire Woodland Park community, and not a decision that is in your individual best interest. So As board members, you have to avoid conduct that violates or appears to violate the public trust and abstain from personal financial gain beyond the officials, beyond your officials' compensation. I'm assuming that does the city pay you all as appointed officials a monthly stipend, or is this completely on a volunteer basis?
Volunteer.
I'm seeing a lot of shaking heads, so volunteer
Volunteer.
basis, that's good to know. Again, you shouldn't be using your position as a board member to gain an unfair advantage over any other member of the Woodland Park community. And conflicts of interest and ethics rules can be tricky stuff, right? So that's why I'm up here to give this this presentation this morning. And this is something that's good to do probably on an annual or biannual basis. And or if there's new appointees to the board, right, from time to time, it's good to have a refresher. So let's do the next slide. I know you're trying to get that. We can just roll with this as long as we can advance the slides. Well, I'll let the presentation maybe catch up here. Oh, here we go. Okay. That's great, Karen. If you can maybe. Okay. Well, again, while they're working on the PowerPoint, so the summary of what I'm going to present here this morning is we're going to do a summary. Thanks, that's perfect. That'll work. So we're going to do a summary of some statutory provisions in Title 24 and Title 31. We're going to then spend some time on Amendment 41, which was a constitutional initiative that was adopted by Colorado voters in 2006. We're then going to drill down on the language related to conflicts of interest that you have in your DDA bylaws. We're also going to spend some time talking about appearances of impropriety and how an appearance of impropriety differs from a conflict of interest under the law. And then I'm going to try to leave some time at the end for some Q&A. My hope is that we can get through this in about 20 or 25 minutes. So bear with me. I know that we're already running a little bit behind schedule this morning, but I'll try to get through this quickly. But again, like I said, leave some time for some Q&A from all of you. I will just note as a preliminary matter that despite efforts by Colorado courts and the state legislatures or the General Assembly here in Colorado to define, clearly define ethical obligations, it's often difficult to identify the precise boundaries, right, of what those obligations are. And this task is made a little bit more difficult by the fact that conflict of interest issues are typically resolved at the local level, right? So there's very limited appellate decisions out there or guidance from the Colorado Supreme Court on what the specific boundaries of the ethical obligations are. So again, here's what we're going to cover this morning. So let's get into it. Next slide, please. So with respect to state law, as I mentioned, conflict of interest and ethical obligations are codified in Title 24 and Title 31 of the Colorado Revised Statutes. Title 24 contains the code of ethics for elected officials, and state law may be summed up as follows. If you have a personal or private interest in any matter pending or proposed to be pending before the board, you should disclose that. You should then refrain from participating and not vote on the matter, right? It sounds pretty simple, but that's what I want you to take away from this is that if you have, a conflict of interest, meaning you have a financial stake in something coming before the board, it's really in your best interest because it's your legal responsibility and in the best interest of the board and the entire community that you recuse and not participate in the ultimate decision. So the Code of Ethics in Title 24 sets out a variety of ethical obligations, including restrictions on the use of confidential information for personal gain and accepting gifts in connection with public service. There's a lot of detail in Title 24, but the bottom line is do not use this position as a board member for personal gain. Next slide, please. So a conflict of interest in statute is something that is a personal or private interest in a matter pending before the DDA board. Unfortunately, the Colorado statutes do not define what a personal or private interest is, but typically that will refer to something where there's a pecuniary interest or financial stake, right, in the matter at hand. Next slide, please. While we're on the topic of Title 24, let's discuss conduct that the General Assembly or legislature has determined, if undertaken by a board member and proven beyond a reasonable doubt, constitutes a breach of the board member's fiduciary duty. Couple of items here I want you to keep in mind, right? The Title 24 clearly states that you should not, as a appointed board member, engage in a substantial financial transaction with a person who you supervise in the course of your official duties. So for example, if the DDA were to have an executive director or assistant executive director, or I know you have a recording secretary, right? You should not engage in any sort of financial transaction, loan arrangement, helping with a car payment, any sort of financial arrangement with somebody that you oversee in your official duties. That is prohibited. Also, you should not perform any official act affecting to your economic benefit a business or other undertaking in which you're involved. So this is pretty straightforward, right? You qualify to sit on this board because you own property within or involved with a business that's located within the boundaries of the DDA. So if the DDA is considering a TIF agreement or some arrangement where the DDA is going to contribute public funds and it's going to impact a business or a piece of property that you're involved with, that's a clear situation where you have a conflict of interest and you should recuse yourself. You also should not accept goods or services from any person who at the same time is providing services or goods to the DDA. So an example of this might be, let's say, for example, you have a third-party consultant that's providing engineering services to the DDA, or an accounting firm that's providing financial services to the DDA. And then this accounting firm happens to come up to you after the meeting and say, hey, because I'm up here in Woodland Park and I'm working with the DDA, I'd like to do the taxes for your business. I want to file your business returns, or I want to file your personal returns, and I'd like to give you a 15% discount on that. Again, that's a no-no. That's prohibited under Title 24, right? You should not be engaging in any sort of financial transaction with a third party that's providing services to the DDA. Now, there's a caveat with that the statute goes on to say that there's a totality of the circumstances analysis, right? And you can get into an analysis of whether the underlying transaction is fair and to both parties, and there's no, but I'm advising you, don't even get in, don't go down that road where you're having to spend money in front of the Independent Ethics Commission in Denver, or in front of ultimately a judge, right, to do this totality of the circumstances, because ultimately it's going to be a waste of your time, potentially some taxpayer money, right, and you will have potential civil or criminal penalties if you violate one of these Title 24 provisions. Next slide, please. Title 24 also includes a gift ban, as does Amendment 41, which we'll get into in just a minute. So as board members, you are prohibited from accepting anything of substantial economic value that may, and this is the language from the statute, may, quote, influence a reasonable person to depart from the faithful and impartial discharge of public duties. So substantial economic value is typically defined as anything more than trivial value. I passed out these pens earlier to kind of make a point. I mean, if you get some swag like this, and you know that this pen is probably worth 80 cents or 65 cents or something, go ahead and accept it, right? But anything more than trivial value that you're given should really raise a red flag immediately, right? And you shouldn't be accepting any gifts. And also, I want to make it clear that this gift ban also extends to gifts that might be received by your spouse or partner or any dependent children, right? So if there's a development group that's doing a project and they end up giving a $250 gift card to Walmart to one of your kids, that's a problem, right? That's clearly prohibited under the law. Now, here are some notable exceptions to the gift ban. Gifts from friends and close friends and relatives are okay, as are winnings from I know the statute goes on to talk about winnings from lotteries or a raffle, or if you happen to win something at an auction or some event, right? That's going to be okay. But violating any one of these gift ban provisions, similar to violating any of the other Title 24 provisions that I talked about earlier, will subject you to potential liability. Next slide, please. So just a quick overview of what is this potential liability, right? So the law is clear that you have both potential civil liability and criminal liability. So in the civil liability bucket, pursuant to state statute, a district attorney, which in this case would be the DA for Teller County, could bring a suit or an action against you on behalf of the people of the state of Colorado against any board member who breaches his or her fiduciary duty to the board. And the breaching member, if you're found to have violated the applicable provision, would be responsible for any monetary damages or consequences of the breach. In the criminal liability bucket, board members are prohibited from being interested in any contract made by them in their official capacity or by any body or board of which they are members. So any contract made in violation of this section is voidable by the other party and is also considered a class 1 misdemeanor, which could potentially subject you to fines and jail time. So I want to have you make sure that you're aware of the potential liability that you have for violating these provisions. Next slide, please. So now let's segue into talking about Amendment 41. This is also largely related or is on the topic of the gift ban. As I mentioned earlier, Amendment 41 was adopted by voters in 2006 as a constitutional amendment. This added a new, quote, ethics in government section to Article 29 of the state constitution. The purpose of Article 29 was to establish new statewide rules governing the receipts of gifts and other considerations by government officials. The main purposes of Article 29 are to encourage propriety amongst elected officials, set out some clear ground rules, and then establish penalties if those ground rules are violated. Under Amendment 41, appointed officials such as yourselves are prohibited from asking for or accepting gifts more than $65 from any one source in a given year. And again, this would include gifts that are provided to your spouse, partner, or dependent children. You're also prohibited from accepting any forbearance or a forgiveness of indebtedness. You're also prohibited from accepting gifts from professional lobbyists in any amount in any year. So I want to stress that last point. Amendment 41 also established the Independent Ethics Commission, or the IEC. The IEC is an independent body that sits down in Denver, and any member of the public or anybody else can lodge an ethics complaint against any elected or appointed official in Colorado. There's a number of published decisions that the IEC has available on its website. I would note that there is language in Amendment 41 that says that home rule jurisdictions, and I know Woodland Park is home rule, if the home rule jurisdiction has adopted its own code of ethics and that code of ethics covers the matters that are generally discussed in Amendment 41, then the home rule jurisdiction's code of ethics will apply. I do not personally know, because I don't represent the city. I'm not sure if Woodland Park has adopted its own code of ethics, but assuming that it hasn't, right, then you all would be subject to the jurisdiction of the IEC. And these IEC proceedings can be costly, they can be time consuming, right? So part of this presentation this morning is I want to make sure that we keep each and every one of you out of hot water, right? And that you're not subject to one of these proceedings down in front of the IEC. Next slide, please. So some exceptions to the gift ban in Amendment 41, similar somewhat to the exceptions to the gift ban under Title 24. It's okay to accept something if it's trivial in value, which is defined as something less than $65 in any 1 year. It's okay to accept unsolicited information or subscriptions or periodicals that might be related to the duties that you're performing as a board member. It's also okay to accept admission to and food and beverage at a reception or meeting at which you're scheduled to speak. Next slide, please. So let's spend a little bit of time running through a couple of hypotheticals on Amendment 41. I want to make sure that you guys aren't sitting up there planning what you're going to have for dinner tonight, and that so I'm going to run through a couple of fact patterns and give you some multiple choice answers, and then we'll see if somebody wants to volunteer and take a stab at the correct answer. So the first one is, let's say you receive a letter from the president of the University of Colorado at Colorado Springs, giving you 2 tickets to next year's football game against CU and CSU to be held up in Boulder, right? These tickets have a value of approximately $100 each. You also know that the university may have a hard time filling the stadium for the event. And has nothing to do with the fact that both teams don't have a win yet this season and are ranked among the lowest programs in the state of Colorado, right? But so let's say you receive that offer for the tickets. So can you accept, right? A, yes, you can accept. This is an important game for the state of Colorado and these programs, right? One of them may ultimately get their first win in a long time. And the value of your time, including the cost of gas to get to and from Boulder, will exceed the value of the tickets. B, no, you can't accept because the value of the tickets exceeds $65 and none of the exceptions under Amendment 41 applies. C, yes, you can accept the tickets because the University of Colorado is not a, quote, person as defined in Amendment 41. Or D, yes, you can accept because the CU-CSU football game is a reception or meeting within the meaning of Amendment 41. And Amendment 41 permits you to receive benefits associated with attending a reception or meeting. What do you guys think?
Well, I would always say B, but your option C had a nuance that is interesting.
About it not being, about the university not being a person?
Yeah.
Under Amendment 41? Well, your initial inclination to go with B was correct.
Mhm.
So here the correct answer is B, right? You shouldn't be accepting the tickets because they clearly have a value exceeding $65. Next slide, please. Let's do another quick hypothetical. So I now know that the chair is paying attention. So we'll see who else is paying attention. So here's another hypothetical. You're asked to attend a reception hosted by the Pikes Peak Courier. The invitation indicates that there will be hors d'oeuvres and 2 drink coupons for every attendee. The invitation indicates that the main topic of discussion will be issues facing Teller County and El Paso County in 2023. The invitation also has some fine print at the bottom where it says the total value to attend does not exceed $65. You have also learned that the event is being paid for in part by a professional lobbyist that works with the Colorado Press Association. So may you attend? Answer A, yes, because the value is less than $65, right? It says so right on the invitation. B, yes, you can attend because you're not going to eat anything and you're not going to drink anything at the reception. C, yes, because you've been asked to participate on a panel that will be convened during the reception to talk about economic development opportunities in Woodland Park. Or D, no, the constitutional prohibition against gifts in any amount from a professional lobbyist is absolute. D. What do you guys think? D.
D.
D?
Yeah.
So that's correct, right? Because the event is being paid for in part by a professional lobbyist. That's something that you should steer away from, right? Clearly. As much as everybody likes free food and free drink, right? But if it comes to your attention that there is professional lobbyist money involved, that's something to stay away from. So next slide, please. So more importantly, I mean, I wanted to give you kind of a little bit of an overview of some of the Title 24 Code of Ethics and Conflict of Interest provisions in Amendment 41. But more importantly, let's drill down on the language that's actually set forth in your DDA bylaws. Karen, next slide, please. So here's the language that's taken, verbatim from Article 4 of the DDA bylaws. It states that no board member shall vote or otherwise participate in any matter in which he or she has a specific financial interest, defined as a matter in which the member or employee receive a benefit or incur a cost substantially greater than other property owners in the DDA. So earlier, I let you know that state law doesn't do a great job of defining what a personal or private interest is. I'd say that your bylaws do a pretty good job of helping define, right, what a specific financial interest is here, right? So for example, if you're, an example of a benefit that you might receive that's different than other property owners within the DDA is that if you own property and that property is going to be, purchased or leased by the DDA as part of a redevelopment proposal or sold to a third party, right? Clearly, that's something that the sale or lease of that property is going to have a financial impact on you greater than other property owners within the DDA. So that would be something where your bylaws clearly say that it's the duty to disclose and then refrain from participating and not voting on the matter. With respect to a cost, one example that popped into my mind is, under Colorado law, a DDA is authorized to impose fees or special assessments. So let's say, for example, the DDA in cooperation with the city or another partner was going to undertake some beautification project or sidewalk improvement project, and they were going to impose a fee or a special assessment on a per lineal foot basis or some other basis. And if you just happen to have more frontage along your property boundary than any other property owner within the DDA, that's a scenario in which if the DDA ultimately imposes that fee or special assessment, you would have a cost greater than any other property owner within the DDA. So that's also something where your bylaws say you shouldn't be participating or voting in that decision. Next slide, please. So, let me maybe stop. This is a good place to maybe pause because we just, the bylaws are super important, right? That's probably what you should be looking at first. Are there any questions about the language that's set forth in the bylaws before I move on? Okay, great. So moving on to something a little bit more nuanced than is what's referred to as an appearance of impropriety. Right. So in addition to the statutory provisions that we've covered, in addition to Amendment 41 and the language of the bylaws, the Colorado Constitution requires covered individuals to, quote, avoid conduct that is in violation of their public trust or that creates a justifiable impression among members of the public that such trust is being violated. So what we're talking about here is that justifiable impression bucket, right? An appearance of impropriety is generally involves matters that include a perception issue, or sometimes you might hear somebody say, "Well, hey, that just doesn't pass the smell test," right? Something's a little bit off there. So an appearance of impropriety can weaken public confidence in government and create a perception of dishonesty, even if you, as an appointed official, are technically in compliance with all of the legal requirements. So let me give you a couple of examples here, because I think examples might help flesh this out a little bit more. So let's say that you sit as a board member on the local YMCA or a steering committee, the YMCA, or some other local community group, right? And that group, the YMCA or that other group is in front of the DDA with a funding request so that they can improve sidewalks or infrastructure in front of their building to improve ADA accessibility, right? I'd say improving ADA accessibility is probably something that everybody can get behind, right? Not super controversial, but again, you have a relationship with that group that's in front of the DDA requesting funding. So I would throw this back to you all and say, is that something where you should be involved in that discussion or be involved in the ultimate decision of whether public funding will be approved for that request? What do you guys think? I see John shaking his head no. But you know what I'm saying? This is something that you don't technically have a conflict of interest under your bylaws or state law, but something's not quite right, right? Because you have a relationship with that entity. So that is one potential path, right? Is to take the same path that you would if there's a conflict of interest, which would be disclose that, recuse yourself, and not participate in the discussion and just abstain from voting, right? That's one path. The other path would be to disclose that on the record, either orally or in writing. Disclose that you're a member of the YMCA board or this other community group steering committee, and then state on the record that notwithstanding that involvement, that you believe that you can make a fair and impartial decision based upon the facts that will be presented to the DDA. Ultimately, that becomes kind of a personal decision, right, for each of you. Does that feel right or not, right? And these are tricky. These appearance of impropriety scenarios are tricky. So I would always say if one of these arises, right, make sure that you call me or call an attorney in my office. We'll walk through it, right, and talk about kind of best practices. Second example that I would raise is let's say that there's a new business proposed to go within the boundaries of the DDA, and it's a marijuana club, right, or something that might be perceived in the general public as something a bit more controversial. And one of you, let's say Rebecca, the new board member, before she was appointed to the board, when as a private citizen, or even after your appointment to the board, you have written letters to city staff and city council clearly in favor of this business, right? That you say, hey, I know you guys have a hearing on a special use permit coming up. You've got to approve this. This is the best thing in the world. And then the city ultimately approves the entitlement package for this business, and construction has started, and then they come to the DDA with a funding request. Should Rebecca, as a DDA board member, participate in the discussion of that potential funding and make a decision on that matter? What do you guys think there?
She doesn't have financial interest, correct?
She doesn't have a financial interest in that. She doesn't have any interest in the property in which this business is being located. She's not a member of the LLC. She doesn't have any financial business interest in the entity itself. But she has written letters in support of that land use to city council. What do you guys think?
I guess I would weigh in that despite potential appearance of impropriety, she also doesn't give up her right as a citizen to weigh in on local matters. That would be my perspective in this scenario.
To weigh in on local matters, right? I think that the risk here, right, or the question is whether her letters that were sent in support of the business could be perceived as her having a bias, right, or any sort of prejudgment as to the funding request that'll come before the DDA, right? And that's what we really want to be focused on and that's what we would discuss, right? When these appearances of impropriety come up, those are the real honest, the honest inquiry that you have to have with yourself is have I prejudged this request in any way, or do I have a bias, right? And if the answer is yes, then the most conservative path is obviously take that same path that you would take if there's a conflict of interest under the law. So next slide, please.
So would you consider the potential prejudgment aspect kind of an overriding factor to just say no?
I think so, for sure. Definitely, right? But if it's, one other example that I would give is, let's say that a group that's in front of the DDA for a funding request is a corporate entity, kind of a entity that may have a national presence, and you have a second or third cousin that lives down in North Carolina and his or her spouse happens to work for this entity, right? I mean, at some point you get to a point where, yes, could you be perceived as having some sort of bias or prejudgment? Maybe. But I think that's why disclosing it on the record and saying, yes, there is a remote familial relationship here, but we never see these people. We don't host them at our home for any events. I personally don't have any financial interest whatsoever in this business. And based on that, I believe that I can make a fair and impartial decision on the funding request that will be coming before the board. But I think Chairman Perry, you're right in that if when we discuss it, if it's more probable than not that there's been some level of prejudgment or maybe a bias that has been shown, then the most conservative and best way to handle that would be to disclose, refrain from participating, and not vote in the matter. So with an appearance of impropriety issue, you may not be at risk of civil or criminal liability, but you have to remain conscious of whether your relationship with a specific individual or group would cloud your ability to render a unbiased decision. And again, I already mentioned this, but if one of these situations arises, best course of action is to email me, pick up the phone, call me if I'm not available, talk to another attorney in my office, explain the nature, the background, and then we can come up, we can chart a best path forward regarding the appearance of impropriety. Next slide, please. So just a couple of items to kind of summarize where we've been. I want to make sure that everybody remembers that both under Title 24 and Amendment 41 with respect to the gift ban provisions, it's important to remember that that applies to both yourself as well as your spouse or partner or dependent children. And again, I said the best thing to do on conflict of interest situations is to look to the bylaws first, because I think the language there is very informative. And quite frankly, the language in your bylaws is verbatim taken from Section 3125.819 of the Colorado Revised Statutes. And that says that a specific financial interest involved any matter pending before the board where the member would receive a benefit substantially greater than any other property owner, or incur a cost substantially greater than other property owners in the DDA. Next slide, please. So what must a board member do if a conflict of interest exists? Do not vote or influence the decision. These are the steps that you should follow prior to acting or voting. Disclose the nature of the conflict. And then following disclosure, do not participate. And the language that you see in quotes there is just language taken straight from the bylaw section that we had up earlier. The board member shall thenceforth refrain from voting on or otherwise participating in a particular transaction involving such interest. So what is I think you guys have done a good job of this, because I reviewed your minutes from the last meeting, and I know two of the board members apparently declared a conflict, and it said in the minutes, left the room, right? So I want to just spend a minute talking about that, because I think it's important, right? Refraining from participating, in my view, clearly means you leave the room, right? And the reason I say that is that if somebody declares a conflict of interest, let's say that the DDA is going to be discussing the acquisition of your property, right? You've declared the conflict. You shouldn't come down here and sit at this table, right? And glare at all of the board members, maybe have alarms crossed or something, because your physical presence might end up impacting the decision, right? I had a scenario in one of the jurisdictions I worked with a couple of months ago where one of the board members declared a conflict of interest because he was a board member of the HOA. There was an issue involving the HOA that came before the city council, and he declared the conflict, and then he turned to everybody and said, well, I've declared the conflict, but I'm going to stay here and listen to the discussion. No, you're not. Because you want to make sure that your physical presence is not chilling or having any impact on the discussion, right? And this kind of goes without saying too, but not refraining from participating doesn't mean just leaving the room and then we come grab you and come, bring you back into the room afterwards. It also means, don't pick up the phone and be calling everybody after the fact to figure out who said what in favor of the proposal and who was against it, and don't try to make those calls or emails in advance of the discussion. Don't try to influence the decision in any way. And I would also say, definitely stay away from social media, right? To the extent you guys have Facebook accounts or Twitter feeds or whatever you guys might have. I personally don't because believe me, my kids would tell you I'm no fan of, I'm not very good with technology to begin with. And I found that I just don't have the time for some, but if you guys have social media accounts, that's great. Don't be bringing these DDA issues into any sort of social media discussion. Next slide, please. And again, what must you do if there's an appearance of impropriety? I'd say in that event, call me, right? Let's talk about it, right? Because again, the main inquiry is going to be whether there's any level of prejudgment or bias, or maybe even more importantly, whether the public or other third parties would perceive that there's been bias or prejudgment. And you may tell me if you call and say, look, I really don't have any prejudgment or bias here, none. I can be fair and impartial. Given the situation and given the nature of the request and who's involved, it might be in the best interest of the board, though, for you to take the more conservative path of not participating. Part of the beauty of having a 9-member DDA board is that even if 1 or 2 members have to recuse themselves from a decision, you still have a lot of board members that are available to clearly listen to the proposal, discuss it, make a decision on the merits of the proposal. Next slide. Again, here's just a summary. So conflict of interest refers to a financial interest, which could be direct or indirect. A breach of a conflict of interest provision in Title 24 could subject you to civil or criminal liability. As I mentioned earlier, I would say look first to the language that you have in your DDA bylaws regarding conflict of interest. Beware of gifts, right? Especially gifts from professional lobbyists. When in doubt about the value of a gift or who's giving the gift, right? Ask questions, be inquisitive, right? Don't just accept things blindly, right? Really pay attention to that stuff, because even though it might seem like something has trivial value, maybe it doesn't, right? And like I said earlier, you don't necessarily want to be in front of the IEC because somebody files a complaint against you as an appointed board member. And then, let me just end by saying, look, every decision you're going to make as the board member has potential ethical pitfalls, right? And when you're doing that internal analysis of, hey, do I maybe have a little bit of prejudgment here or bias, or could I be perceived as having that? I like to follow this rule of thumb, which is, when you're making decisions, make them knowing that what you say and what you do may end up on the front page of the newspaper, right? And if for some reason that makes you hesitant or gives you pause, and you're like, well, I wouldn't be that excited, right? If this bit of information got out to the press and then I was perceived as having prejudged this or having bias, then that should, again, red flag, right? That means that's something that you should call me, we should talk about, right, in advance to make sure that we're handling it correctly. So again, this is, I wanted to keep this relatively short this morning, but provide an overview. As I mentioned earlier, this is good to do on an annual or maybe biannual basis, or if you have turnover in the board. But again, let me stop there. Are there any questions or, yeah?
You didn't touch on malfeasance. If you suspect a board member has a conflict of interest, you say to contact you, is that the best?
Right. What you don't have in your bylaws is sometimes if you look at code of ethics for other jurisdictions, right now the duty to disclose is on the board member that has the conflict. Mm-hmm. So you're talking about a situation where you think there's a clear conflict of interest, but that hasn't been disclosed.
Correct.
So I would say best thing to do there would be to call me and make me aware of that situation. I can then contact the other board member and inquire into that, right? It should be pretty relatively cut and dry on the conflict of interest scenario in determining whether that board member has a financial interest or would have a benefit greater than any other board member within the or property owner within the boundaries of the DDA or incur a cost.
So if this person with a conflict of interest fails to notify that they have a conflict of interest, that constitutes malfeasance, is that correct?
That would be yes, that would violate the bylaws because the language in the bylaws says that willful violation of this section constitutes malfeasance on the part of the member of the board and is grounds for instant dismissal of any employee, right? What I would note is that the statutory section in 3125.819 contains some additional language which says that the governing body may by ordinance provide for automatic forfeiture of office by a board member for violation of this section. Currently, I'm not aware if in the ordinance originally creating the DDA, if the city council provided for that, but that's something that I can look into. But ultimately, that if there is a conflict of interest and there's a willful violation of that, number one, it constitutes malfeasance. Number two, you can be summarily removed from the board.
Yeah, so with that, I would like to give a scenario that you could take with you for consideration pertaining to myself, suspecting that that may be the person Mr. Good is referring to, as the other two parties have recused themselves. So I've been on a multitude of boards, including quasi-governmental. Before coming on this board, I always, if I perceive potential issues, I talk to one of our attorney firms, Stinson up in Denver, which I'm sure you're aware. And basically the question was, if I'm coming on this board as the CEO of a local community bank that does a lot of business in this community with a lot of adjacent property owners to the DDA Woodland Station property, a lot of businesses within the district, what are my potential pitfalls? So my perspective based on consultation with the attorneys was right up front, and I think I said this to the city council when they were deciding whether to appoint me or not, I made the commitment that Park State Bank would not participate in any funding on Woodland Station, period. End of story. So adjacent properties, can't say that because we have loans all around the property and within the district. But I would also argue that over the years, different DDA board members have publicly stated that they didn't want anything built in Woodland Station because they were afraid something might block their view, or they didn't want a restaurant built in Woodland Station because they didn't want another restaurant, or they didn't want anything in Woodland Station because they perceived it was unfair for another party to come from the outside and open a business. So those are three factual statements on the record. So I guess I would ask you to consider, because I'm guessing, is that true, Mr. Good, that you're
No,
directing
my
that towards
comments
myself?
were not directed at you.
Hmm.
But the fact that you come in and recuse yourself at a later point when in fact you've been dealing with the parties surrounding Woodland Station and with Woodland Station all along does not give you a get out of jail pass, in my opinion. That it was knowingly and willfully violating that, and the people that put the people on the board are as guilty as the people that are claiming no conflict of interest.
So obviously, this is an issue that you should probably consider. I would suggest you can reach out to Mr. Good and get his very educated guesses at what the law is. But and then reach out to any parties you would like, including the city council, including myself or my attorneys. Fair? And as I've asked before, if you're going to make accusations, I'll take your attorney's number.
I have not made accusations at any person directly.
Okay,
Well, maybe before I leave, Jerry, let me make sure I get your number, and we can talk about it offline, right? So just so I understand the background and what your concerns are. Okay, so I'll make sure I've got your contact information. So that's all I had in terms of a prepared presentation this morning. Thank you for your attention. I hope I stuck to the 20-25 minute time
did.
estimate.
no, I think your recommendation, because this is really important and some things like this needs to be top of mind, especially, we have Woodland Station coming online. We have potential up to 6-7 businesses coming to us for TIF agreements within that property. And so it's going to get pretty interesting, I think, in the next couple of years. So the only other thing I would say that's kind of bugged me, because you referred back to the bylaws, and I did see that it was smart for them to take the statute and put that in the bylaws, but the most recent copy of the bylaws that I see have handwritten changes on the bylaws. And I would ask the board if we're amenable to having Mr. McGaskin take a look at the bylaws, not only for cleaning them up, possibly modernizing them with respect to current situation with Zoom meetings, team meetings, because there is some interesting facets of, even if the DDA board member leaves the room, obviously they have access to the meeting publicly via Zoom in this scenario. And so I think my read on the bylaws are they probably could be cleaned up a little bit and modernized just a bit, and then we have a clean copy to move forward from. Is that amenable to the rest of the board from a consensus perspective?
Good idea.
Is that okay?
Yep, I can take a look at it. I mean, if, I don't want to fix anything if it's not broken, right? So I'll take a look through there, but if there are areas that I think can be improved or maybe clarified, happy to do that.
Well, because of the handwriting changes, I'm not sure if the attorney did it or a DDA member did it.
Right.
I think it would be smarter, cleaner for us just to have a fresh copy from our attorney
Yeah, adopted in,
and adopt it once you present it back.
okay, sounds good. Happy to do that.
Chair Perry,
Yes, sir.
this is Councilmember Neal. I do need to leave the meeting at this time. I have to check out of my STR and get to the airport.
Okay. Thank you, sir. Thank you, Mr. McCaskey. Okay, we're gonna forge ahead fairly quickly. We'll try to get out of here before 9. Thank you, sir. That was very helpful. Okay. Again, I've already communicated that we're gonna have informal conversations, get to know you sessions between attorneys, between 2 board members and the TAVA group to start talking about nuances of the contracts. And as usual, those nuances will be voted on by the entire board. It won't be done in a vacuum. And then once we come to an agreement as a board and TAVA agrees, then we'll execute the contract. So it is taking longer than TAVA wants, but we have a duty to make sure that we check every box in this process. I'll give you a quick update on B, C, D, E, and then F. So Mr. Gamelki did reach out to the previous chair to get some information on the UPass Historical Society. And what I will say is she communicated that she had given the information to the city, and we haven't been able to verify that with the city. And so Mr. Gamelki and I are going to go straight to the source and work straight with the Historical Society. KSU Brownfield grant opportunities. Rebecca and I are signed up to do that. We do have information from Mr. Arnold. He's the economic development planner for Durango and the Brownfields project with KSU. Ms. Riddell had kind of an important thing going on, like a wedding and a honeymoon. So we'll hit that hard here in September. the Downtown Colorado Initiative that Mr. Bourne and I will be participating in. We'll also hit that with a vengeance this month with Downtown Colorado. But we're also going to add in, I had a meeting last week with Beth Wright, representing the Colorado Tourism Office. And most of this was facilitated by Grace Johnson from the city, by the way. But she reached out, and with the city's efforts, they look towards moving towards some kind of economic development perspective. And they were asking about the DDA's interest in participating in that. On the surface, it appears to be within the boundaries of what the DDA can be doing. But Mr. Bourne and I will get more information, bring it back to the board and make sure that we had spent time, resources in that process. But it looked pretty interesting. We haven't heard back from OEDIT yet, and that's it. The only other thing I'd like to discuss is 6A, discussion on DDA position regarding property rights. I just want to make sure that we're all on the same page. Part of our duty is to address blight in the community, and I'm not talking about a little trash in the gutter, as it was communicated a few years ago. I'm talking about potential blight. I have a hard time personally. I mean, each of us personally can make a decision on what blight might be, and we may have different definitions. You know, and I guess I want to make sure, at least on it, we don't have to vote on it, but I want to have a consensus one way or the other that with respect to property rights, there may be multiple properties that we may deal with as a DDA within the district, or even within Woodland Station or adjacent to Woodland Station. My personal position is that property owner has a right to that property and to do with it what they will, no matter what we think or what we want. It doesn't mean that we can't offer to do a TIF deal for improvements or things like that. But I guess I want to make it clear from my position that as the DDA chair, I will never support or advocate deciding a property's disposition for the property owner, if that makes sense. I mean, it's not our duty, it's not our job to say, we don't like that property, let's make it go away. And I'll give you a quick anecdote. I got invited to a DDA meeting about 5 years ago with Mr. Lawson's predecessor as city manager, Ms. Riley, Ms. Larson, Mr. Coy, Mr. Kratt, a developer from the Springs. And at that luncheon at the Swiss, it was recommended that the city basically declare the trailer park a blight on the city and condemn it. And I think it made a few people at the table uncomfortable. And I stood up and said, if that is the tenor of this meeting, I will not participate. We don't get to decide whether a business is good enough for our community or not. And the city managers had to back up and say, yeah, we can't really condemn it. So my point is, I think this has been a topic of discussion based on looking at some meetings recently. And I want to make it clear that we're going to be reaching out and letting businesses in the district know that we can assist, that we can help them improve their properties. We have mechanisms for that, whether it's through all these grant opportunities we're exploring or whether it's through a TIF. I intend, and we've indicated that we're going to be proactive in helping to strengthen our downtown corridor, but not at the detriment of a property owner in the district. So I just want to make sure that we're all on the same page, because I've heard some contrary discussion out there, and I want to understand where we're at so that I'm not leading from behind, so to speak. So does anyone feel differently? Let's put it that way. For instance, the old Martini building, there's been discussion about that. our intention should be to reach out to that property owner and to say, can we help you with rehabilitation? You know, is there enough delta there to make it worth your while to rehabilitate that building and make it more of a positive projection for the city? So that's an okay ask, but asking them to tear it down, probably not an okay ask. So does anyone feel differently, or is there any conversation, discussion? Yes.
Well, that building has been in a quasi legal battle or something.
Mhm.
And also, I don't think that it's our position or should be our place to have a comment or maybe even reach out to them at this point. Because I think it's really none of our business right now.
Yeah, it is out of legal and it is on the market.
Is it?
It is. So it's okay to reach out and communicate to them. In my opinion, that's just not, you know, but I don't disagree with what you're saying in that scenario. So anyone else?
I agree with that. I agree with reaching out to you know, local DDA businesses that look like they're struggling, need help, and you know, structures that need help, and reaching out and seeing if there's a way to, you know, to facilitate or help.
I have a question. What if there's known businesses that are receiving TIF that are not improving their property?
Well, yeah, so the TIF deal had specific language and agreement in the agreement, and they satisfied the agreement. Doesn't speak to future maintenance, doesn't speak to future issues. At least most of the agreements I've seen do not address that. So I don't think there's an issue there with respect to, now that doesn't mean that we can't, that would be difficult too. Because typically the TIF agreement is for a set delta on a improvement from A to B, and to try to figure out the future will be difficult, I think, even for the best attorneys. So, yeah, so I think the past TIF agreements have already been executed, and they did their part, and so it's up to us to pay them back, and I think that's where it lies. So.
In the state enabling legislation, the word blight does appear. One would probably find it be very difficult to describe blight because each person would have a different reflection on that. It certainly should not be the purpose of a DDA board to take an eraser and remove the blight that way, but utilize whatever the assets and skills that we have in a DDA board to work with the owner if they wish to improve that to a different level. Again, the beauty is in the eyes of the beholder. So one must be very sensitive to that. Yes, we can help, but we should not destroy.
Yeah, and I want to make it clear that even though we have the TIF as a tool available to us, you know, we're exploring all these other options with a vengeance, which are looking for funds, grants. For instance, again, the KSU program, the Brownfields program is under the EPA, and my position, whether I like government funds or not, is why not bring those funds to our community if we can. So that's the effort we're really going to expend, and also maybe just make it clear, because I've seen some businesses in the district the last couple of years do a great job of rehabbing their businesses. Even the Taco Bell. I mean, if you look at what they did in improving their appearance, and they didn't take advantage of TIF, which is great too. But my point is I think that's the message we want to send: is we're here to help. We'll reach out and let you know of the opportunity, and then also maybe let you know about some of the other opportunities out there that we can maybe help take a lead on with you. So anyway, so thank you for that. I think we have a consensus that the reflection of whether it's right or not is hard for us to determine. We're just here to help those businesses in the district improve. So thank you for that clarification.
Tony, I have to take off.
Yes, sir. So real quick, well, I don't know real quick, this is important. Woodland Station development update. Mr. Weaver did such a great job last time. It looks like he got.
Thank you. Good morning, everybody. Okay, so we've had a lot of meetings in the last 30 days. We're talking with our attorney, Paul Kloster, who's right there. He has a rough draft ready for the agreement for disposition and development. We'll get that over to your attorney for his comments. We met with Echo Architecture to continue work on the site plan. And we've got one iteration, we're working on another iteration. So that's in motion. We've met with David Weekly Homes to get their inputs into things. We've talked with our civil engineer multiple times about the property, about utilities and infrastructure and access. So it's all, y'all, it's all in motion. We're just proceeding like this is all going to work out just great. So it's exciting. We're excited. We're talking with adjacent landowners as well. So we keep moving forward. Do you have any questions? Anything you want to know?
Well, I guess I would like to bring up a few things just in general that have kind of popped up that we've discovered
Please.
over the last month. One is the VCUP, which was the 532-page environmental for Matrix Engineering, has expired. There was a 10-year time limit on it. Good news, bad news that it expired. The Tava Group reached out to Matrix, met with them, and I believe, and hopefully you'll confirm, that they basically said they would update the phase 1 environmental and the VCUP.
Yes, sir. Correct.
For $10,000.
Roughly.
Did I hear that
Yes, sir.
right? See that right?
That is
I
correct.
saw that email come in.
And we're just
couple
going to move
days ago.
forward with that board. We're going to engage them to proceed and just move forward with that.
Yeah, that's that. When I learned of the VCUP being expired, that scared me because the numbers I've seen on the cost of that VCUP were, I've seen invoices to the total of $350,000, but I've heard it was as much as $750,000. And so $10,000, I kind of went, that could have been a deal killer. So I think that's what I heard. And, you know, we don't have, we will commit to Mr. Gamelke and I with getting with Historical Society, because we know that you have no interest in the picnic tables, you know, have no interest in what I call
Stagecoach.
the stagecoach tetanus shot waiting to happen piece of art. And you have an interest in making it work for the cog rail. So we're going to meet Mr. Gamelke and I with Mr. Carter as well.
Okay.
And one other thing I will throw out board that you can maybe expect some discussion out there. And of course, everything we do will not be codified without us weighing in and discussing in public and voting on eventually. But right now, there's also the possibility of reimagining Bergstrom Park in terms of how it looks down into the Woodland Station property, going back and getting historical references on Mr. Bergstrom and what his intent was. And Tava has communicated wanting to pay homage to the Ute Indians and some other things in the Saddle Club history there. So we may actually bring that up at a meeting here shortly, just to discuss that, to encourage you to think about that. The city seems amenable. And I think the city's amenable to leaving it as is or reimagining. I've always been a big advocate against the little crumbling amphitheater over there.
Right.
I've made that known. So anyway, so I think it's worthwhile the discussion right now before things really get going. Does that seem reasonable to the board?
Yes.
Okay. Okay. Okay, any questions for Mr. Weaver?
Yeah.
Okay.
Is it possible to get a more of a detailed development plan? I mean, there's a lot of issues that still haven't been addressed. And before we actually sign a contract, I think that we need more details.
Yes, sir. In that ADD agreement, it has a lot of exhibits that goes with it that will show the concept plan, the plans for it, and a construction timeline.
Cool. Thank you.
Would that be helpful, do you think?
Absolutely.
Okay.
Just because I love architecture, how soon will we be seeing updated renderings?
Well, that's a good question.
Maybe I'll call the architect.
So what Echo's working on right now is the site plan, where the building's gonna go, what's the placement of them, what's the access, where are the roads? That's what they're working on right now. Then they'll start working more on, you remember the old Tava rendering that we had? It will not be dissimilar, but it's gonna be a little bit different. I know that's vague. But it's, yeah, it is. It's gonna look a little bit like what we have already presented in
Okay.
terms of that, but the soaring roof line and that sort of thing probably will not be a component of it. We need to figure out the upstairs, second story restaurant decks. It wasn't in that first rendering. So we'll need to work things like that out with Echo.
Great.
Thank you.
Look forward to it.
Yeah.
Okay. Any discussion on items not on the agenda?
I have one.
Yes, ma'am.
I have a new last name.
Uh-oh, we can change it. What is it?
It's Anderson,
How do we spell that? Because there's different versions.
Anderson.
We will get your name tag changed and everything. We'll even make the IT. Congratulations. We'll also get IT to change your email.
Okay, great.
Okay. Anyone want to come up from the audience for 3 minutes? Uh-oh, of course, kitten. Come on up.
I waited to see if anyone else wanted to go.
I'm just gonna put you on the agenda.
Okay.
3 minutes though.
Okay. Tell me when to start.
Okay, thank you. Am I starting?
Yes.
Okay, so from what I understand from the attorney is that the Colorado statute is very clear and the bylaws are very clear, yet there are behaviors that, and I don't know if I should call them behaviors, but you'll understand in a minute, that could appear unethical and you want to avoid those things. And so I just want to reiterate something that I've said in the past, that Rusty Neal being on 2 boards appears unethical. And again, it just, for my confidence in the DDA and the city council, him being on both really does lower my confidence in the decision-making. So there's one. The other one is it, well, it appears unethical to have partners from one business on the same board. And it may not be, against statute or against the bylaws, but again, it does appear unethical and therefore lowers my confidence in the decision-making. And then one more, someone had brought to the attention that Mr. Weatherford had purchased some property adjacent to where the Tava House is going to be building. And rumor has it, and I have not checked the facts, so I'm just saying there is a rumor that Mr. Weatherford has recently purchased more property in that area. But in any case, having property and making decisions about adjacent property gives an unfair advantage and appears to be unethical. So that's just my view of what is happening. And the other thing I want to say is that what I heard from the attorney is quite biblical. And I'm going to say it's either 1st or 2nd Thessalonians, chapter 5, either verse 19 or 25. I can't remember, but it's one of those verses. And it says, do not give the appearance of immorality or unethical behavior. So I was kind of excited that your bylaws and statutes are actually biblical. So I'm just going to say a quick prayer. Thank you, Lord, for this opportunity to learn, Lord. Your word says to seek knowledge, seek understanding, seek wisdom, and that the board obviously was seeking these 3 things, and those here are seeking and gaining knowledge, understanding, and wisdom. And Lord, I just thank you that you give the opportunity for each one of us to walk in your word. In Jesus' name, amen. Did I make my 3 minutes?
You did. Just
Thank you.
barely.
Thank you.
Good practice. All right. Okay.
Mr. Perry, Mr. Perry, with regards to point 1 of her comments there, it is my recollection that the enabling legislation at the state level requires that we have a city council liaison person as a member of the board. So that's not a conflict, that's a directive.
Okay, thank you. Thank you for clarifying.
And the other thing that I can clarify is Mr. Weatherford does have an adjacent property which could benefit, which is why he's been recusing himself, which is appropriate.
Okay.
And the third, you'd have to give me more information on that we could discuss later. Is the conflict you perceive between myself and Mr. Bourne? Yeah, Mr. Bourne is on my board of directors at the bank. I don't think there's anything in the bylaws precluding that. And I think it was well known by the council when they appointed me.
Okay.
So.
Okay, thank you. Thank you for clarifying.
Anything else to come before this board?
Move to adjourn.
We are adjourned. We're going to discuss what we're going to go to.
Now see what the rest of the day delivers.
Yeah.
Maybe you'll get your stuff inside before.
Thank you.
Yeah, no, I think we need to talk.
I'm sure that that's not. I will.
The answer, but we've kind of been put under a gag. We're not allowed to communicate with you directly. So I welcome this opportunity.
Stay small. There's a lot going on. Good, man. All right, brother. Good seeing you. Have a great day.
Yeah, have you come see me and I'll direct.
Okay, yeah.
So Anderson moves you up on the list.
I know, I'm at the top now, right? I've never been at the top.
Well, thanks for coming.
Yeah, no problem. I came up at the end of what, May.
Yeah, it's gonna take a while.
Congratulations.
Take a while to get all the-
And I do like your
Takes a
restaurant.
while. At least I suppose coming in.
I like your food.
So Saturday?
I've noticed sometimes the
the services.
Close to the footage here.
It's hard. It's hard. So there's a lot going on in the background people don't see. Yeah.